Bonjour, Denoe Moganuk. Hello, my relatives. I'm happy to be here with you today, sharing a little bit about what has been shared with me on Anishinaabe specifically, um, understanding of treaty. I'm always grateful for a chance to connect with a wider public. It's why I do what I do, knowledge sharing. And so I just wanted to mention that I have designed this talk today to be for a general audience because I'm not really sure on who all is going to be here. And just a little more about myself. As Jeremy mentioned, I'm from Kutaching in Treaty 3. I'm an Anishinaabe man. I belong to the Bear Clan, and my work is really all about coming to understand Indigenous systems of law on their own terms. So not as read through common law or civil law frameworks, but doing that hard work of sitting with our elders and knowledge keepers to try to understand as best as I can what our own system of law is really about. And so that's the perspective that I was asked to bring today. So the first point I wanted to make is just to draw a distinction between different accounts or visions of treaty. And all of us in this group today are probably familiar, even if only indirectly, is the Canadian law account or vision of what a treaty is. And not that there's just one, but there's a common framework within which folks agree or disagree. And so a perspective on Anishinaabe perspective, as distinct from a wholesale Anishinaabe account of treaty, would be something like the Restool case. So this was a case many of us will know about, and the evidence is quite amazing that was filed in that case and given orally from Anishinaabe elders, including Fred Kelly, of Anishinaabe perspective of what treaty means. And the goal in that case was to accept the Canadian law account or vision of framework and all of its doctrines, but then to argue that the terms of treaty under that vision, which is a contract vision, need to change. So that's one approach, right? It's just putting forward an Anishinaabe perspective within a reigning or governing account or framework or vision of treaty. But I'm actually talking about something quite different today, which is a distinct Anishinaabe law account of what a treaty is. And the first point I wanted to make is simply that none of us has a God's eye view of treaty. So when we speak about treaty or vision or framework for treaty, and so it's our job, in my view, to be transparent about what that account is, right? There is no discussion about treaty that can happen outside of some particular vision of what a treaty is. And so we had better be open with one another about the vision that we're working within. And so I'm going to talk very briefly today about the Canadian vision of treaty because it's already received extensive airtime and continues to do so. And then I'll spend most of my time with the view of treaty from Anishinaabe law perspective. But just before moving to the Canadian account, I wanted to transparently say that I am not neutral and I don't pretend otherwise. So I'm not just going to share Canadian and Anishinaabe accounts of treaty as best as I understand them, but I want to go a step further and share that on my view, I think the Anishinaabe, and I would say Indigenous accounts more generally, hold more promise. And so I just transparently recognize that, but of course, it's for each of us to come to our own conclusions about that. So to begin with the familiar, and those of us with a legal background, much more familiar, but I think all of us will have some sense that the Canadian vision of treaty is one of contract. Very simply, a settled agreement between parties. It provides certainty for everyone who is party to it. And the Supreme Court has been very clear that it's a special kind of contract. So it's not an ordinary contract. It's a matter of constitutional law, not the private law of contract. But the theoretical framework is that of contract. And all folks in Canada, Indigenous or not, have been working in this framework for a very long time. And so often it's how our own people speak and think about treaty today as well. And there's very good reasons for that. And I won't get into the case law, but for those who are interested, this vision of treaty was laid out to the Supreme Court, cases like R.V. Badger, R.V. Marshall, and more recently in 2014, passage in Tsilhqot'in Nation as well. And this vision of treaty, which many of us just take for granted, simply says that a treaty is a settled agreement. And because it's settled, it can be reduced to a document. So that when we speak of a treaty, we literally mean words on paper. There are provisions, often numbered, and like any other contract, the document or the settled agreement distributes rights and obligations on each side. And a critical feature of this vision or account of treaty is that this dynamic of distributing rights and obligations is zero sum. So the obligations are the direct cost of the rights, such that where one side gains, the other side incurs a loss. And ideally, the amount of losses and gains balance out so that it's an equal document. But whether it is or not, this is the dynamic, that one side's gain is the other side's loss. And so it's an adversarial model of contract, and predictably, it often leads to conflict. And so courts are called on to pronounce on the truth of treaties. There are winners and there are losers. And so many of us, and certainly myself, would characterize this account of treaty as anti-relational, in putting the interests of Indigenous peoples and settler peoples against one another. Arguably, it pits Indigenous peoples and settler peoples against one another. And so we are often in these contests in court over what a treaty ought to mean, or just perhaps some portion of it ought to mean. Now, we have to notice what's happening here. In Canada, there's a constitutional doctrine of separation of powers. And so the legislative, executive, and judicial courts, arms of government, are separated. So when I say the courts and the crown, they're distinct, and they're different bodies with different jobs, and quite often very different perspectives. But the point that I want to make about what's happening in this model is that despite this distinction, this very important distinction in Canadian constitutional law between the court, the decision-making body, and the crown, the government, who is one of the parties in treaty litigation coming before the court, despite this division of identities, both bodies, the court and the crown, are bodies internal to the Canadian legal system. So the arbiter of truth, that's to say the decision-making system itself, is actually that of one of the sides in this treaty contest, Canadian law. So I've never heard anyone say that the idea of a judge or a court is an institution under Indigenous law. And so my first point is just to say that on a structural level, even before we get into the substance of any given treaty and what a disagreement in court might be about, on a structural level, there's an imbalance. And that's to say Indigenous peoples are called to come into what is unequivocally an institution, a vital institution of Canadian law. So why would Indigenous peoples agree to operate under such an arrangement? Especially when we do turn to what is purported to be the content of treaty documents. So I suspect everyone here today has read or heard orally recounting of the treaties. And so they contemplate many things in their various provisions. And they change dramatically depending on which treaty era, different characters. For instance, if we're talking about the numbered treaties 1 to 11, or if we're talking about pre-Confederation or Georgian treaties, they're about different things and they have quite a different feel. What's at stake in them changes. But in the numbered treaties, which are the ones most of us are most familiar with, Indigenous peoples typically get things like $4 a year, a chief's outfit, farm implements of various kinds. And it seems difficult from a contemporary standpoint to reckon why Indigenous folks would enter into an agreement like this. So on the contract vision is a real challenge to construct a reasonable Indigenous position for the kind of exchange that is purported to have been agreed to. And it seems to me that it's quite difficult. I'm not convinced it's possible if we're being rational and fair-minded to construct such an account. Even if we go imagine ourselves facing the decisions in the late 1800s, for instance, in the case of the numbered treaties, most of them, some in the 1900s, to me, it defies reason, and it's hard to tell the story with a straight face if we understand that the bargain was Indigenous lands and jurisdiction for what seemed to be fairly trifling matters of the sort I just mentioned a moment ago, that each Indigenous person receives $4 a year, etc. So how can we account for this, if it can be accounted for at all? So one possibility, it seems to me, is we can simply acknowledge the falsity of that story and begin an inquiry into what a better one might be. Or we could say that the threat of war or some other kind of colonial reduction, as was in fact occurring in the US at the time, was sufficient to secure Indigenous agreement. So maybe the bargain is imbalanced, but given the potentially far worse consequences, Indigenous peoples chose to enter into those agreements. And then we would, though, also have to we would have to say that that choice was legitimate and freely made. And so there may be some tension that works in there in order for the agreement to be genuine. But the difficulty is that none of the treaties say that, right? None of them acknowledge a threat of war in the background as a basis for coming together, or and in an account of treaty that's centered in words on paper, that kind of matters. Also, factually, it strains one. So the treaties were signed in different geographies with different politics and different tensions in different years, decades, and as I mentioned, even eras. Might be quite a challenge to suggest that a background threat of conquest is what moved all of them as a general justification for Indigenous agreement. And then the last challenge that I would have to this kind of story is that even if we can tell it on the facts, the cost of doing so seems really high. It would seem to undo the story that Canada tells about itself and all the world about its constitutional foundation in principles of justice. It seems to me we would no longer be a beacon of light in a world of frequent domination, and rather we would become just another empire. It essentially undoes the narrative of Canadian constitutionalism as we know it. So for me, the story is essentially not bearable on an affective level, my feelings, but also I don't feel that the facts can bear it out. So why does Canada continue to tell it, a story like that? And the answer that I've come to is that its stakes are its sovereignty itself. And of course, this is not, I am not the one who has produced this view, it's a commonly held view. There are three ways under what was formerly the law of nations, but today public international law, through which one state can acquire territory and jurisdiction over new lands. And those are through discovery, there's no one already there, conquest, or cession. That's to say, there's a party already there, but for whatever constellation of reasons, they agreed to cede their title to their land and their jurisdiction to the newcomer. And two of those options have effectively been eliminated by the Supreme Court of Canada, and in the two paired decisions in 2004, the Haida Nation case and the Taku River case, the Supreme Court eliminated conquest as an option. It says that's just not the story in Canada on the facts. And then in a 2014 decision, Chilcotin Nation, they have effectively eliminated discovery because they're saying that the doctrine of Terra Nullius did not apply in Canada. That's a view that Indigenous peoples weren't properly humans. So we were there, but we didn't count. And they're saying that that doctrine didn't apply here. And so without it, the discovery option can't get off the ground. And so there seems to be two of the three options removed for Canada's claim to sovereignty over what I and many of us think of as Indigenous lands and jurisdictions. So that just leaves the third option, cession, where one party agrees to give up its lands and its jurisdiction to another. And we call those kinds of agreements between peoples or nations treaty. But in Canada, and so this is presumably the story that Canada needs to tell, having lost two options effectively. But Canada doesn't expressly own the story, right? Canada does not say, the legitimacy of Canadian sovereignty turns on treaty. Well, it needs to be able to say that, but it can't quite say that because there's first of all, treaties aren't settled everywhere, but there's a circularity problem with this treaty account. So on the one hand, there's treaty rights exist in Canada's constitution. Our constitution has many different documents and unwritten conventions, but one of them, the Constitution Act of 1982, has one section, Section 35, which is about Aboriginal and treaty rights. And so there's something of a story about treaty in Canada, that there's an acknowledgement of treaty, but it exists inside of Canadian constitutionalism, which is to say, it assumes that Canadian constitutionalism came first. So as a provision of one of the acts from 1982 of Canadian constitutionalism, there's a necessary assumption that Canadian constitutionalism precedes treaty because it's under the authority of Canada's constitution that there's a recognition of treaty rights. But how do we reconcile that story with a story that says treaty is the thing that justifies Canadian sovereignty? It can't come before and after. And so there's a tension to be worked through here. So Canada needs to be able to say its legitimacy comes from treaty because the other two options aren't available. But it seems challenging to do so when part of its own story is that the fact of its the factual existence of Canadian sovereignty is what treaty rights. So this is a difficult tension to work through, and what it illustrates is that Canada's own sovereignty is at stake. So most of the time in Canada, we don't typically accept that means justify ends, right? And so we wouldn't be able to tell a treaty story that seems on its face deeply unequal for the Indigenous parties, simply because we need to be able to tell that story in order for our nation, in this case, to actually have legitimacy. We don't typically allow that kind of reasoning. Instead, we expect law to be informed by fundamental principles of justice and fairness, peace, good government. And so what I'm trying to say is it seems that this story needs to make an exception to those basic commitments for Indigenous peoples, that Indigenous peoples get singled out as an exception from the application of those basic principles that we all expect all the time under Canadian constitutionalism. That just seems patently unfair. So for me, the contract vision shared by the Crown and by the courts isn't a story worth holding on to. I find it's plagued with problems of different sorts. And so for me, I'm interested in asking whether there's another account, not just Indigenous perspectives within that account. I'm saying the account itself is problematic, not just the positions that the Crown takes in litigating that account, but the account itself. And so I'm interested in finding out whether there's an altogether different account of treaty that might do better by each side, by standards of fairness, justice, equality, etc. And so that's the kind of worry that inspired me to start sitting with our elders and asking about our own meanings of treaty. And so that's what I did. And so let's begin this now, the heart of what I want to share today, where we should, by asking our elders about treaty. I work quite closely for many years with Elder Harry Bohm, who some of you will know. And so I thought it'd be appropriate to begin this part of the discussion by drawing on some statements that he has made. And in this first one that I'm going to quote, he identifies that the very word for treaty in Anishinaabe, our language, means relationship. So he says, quote, "The very word about treaties, agodiwin, means relationship, making relationships with one another. That's what treaty means." And in another statement, he clarifies what relationship really means, saying, again, quote, "Treaty is about relationship. It's about sharing. And so it's about responsibilities, both for the government and our side as well. Obligations to do something for our people. That's what treaty is all about." So a very clear articulation in both statements that treaty is about relationship. So we're gonna work this out. What does this actually mean? But right from the outset, We're saying treaty isn't a contract, it's a relationship. So we have to figure out what that means. We've also, probably all of us, have heard refer to what we might call the earth passages of treaty, for lack of a more artful term. That is to say that treaties shall last as long as the sun rises, the grass grows, and the rivers flow. So we have these statements that treaty from Elder Bone is about a helping relationship in which all sides have responsibilities to help. And then this other statement that the durability of treaty was tied into what elders typically call natural law. So when they talk about as long as the sun shines, they typically, the discourse used to explain that is natural law. So I want to see where the view that's underneath these statements comes from. So to apprehend what treaty means from the standpoint of Anishinaabe or any other Indigenous people's system of law, we first have to learn something about the foundations of those systems of law. And then we can come back and see the bearing that they do or don't have on treaty. So I'd like to spend just a couple minutes in a very basic way for a general audience, unpacking some of what I've learned over the years, the sort of the background that is animating those kinds of statements that we just looked at. So the first piece here is that everything, wherever you're sitting right now, and you look outside, creation, or the earth as we know it, is the expression of a vision that Gijimanido, our creator, had. And he brought that vision into being. And so he created each order of being and the individuals within each order. And as Anishinaabe, we often talk about those Manidusak, the insects, the swimmers, the crawlers, the two-legged, and the flyers. And within each order of being, various animals, plants, physical features of the world that for us are animate, mountains and rivers that we say are imbued with spirit. Each of these beings that were created were vested with gifts. And we have a word for this, Minigoziwin. And as I've been taught, it means those gifts from spirit, or some elders actually specify from creator. But this idea that as things were brought into being, their inherent nature is they're vested with gift. And in what elders often call original instructions, each being vested with gift was given an injunction to share its gift with others in need. And so this is often how elders will talk about the rivers flowing or the sun shining. So the sun has that gift of light and of warmth, and the instruction to follow its arc every day to share that gift with us. And it doesn't forget, it doesn't fail, right? Grandfather remembers and carries out those original instructions to share those gifts. So just one example of what I mean. And so you think of each species of animal and each individual animal within that species was brought into creation with the different kinds of gifts and is meant to share them with the rest of creation. So the effect of this injunction to share one's gifts, original instructions, is a state of inherent order in creation. That is, the effort to coordinate one's gifts with another's needs creates a rough kind of harmony. And when it works well, which it doesn't always, most of us, most of the time, sustain a state of wellness. But note what this view of creation says about individual members of Earth community. Each of us is interdependent with all of the others. If it's all the ongoing circulation of gifts with needs, our well-being depends on everyone else's, and reciprocally, theirs depends on ours. And so we're all inescapably connected in this way. Well, on that understanding, the fundamental norm, or elders will often say law, of this view of creation is sharing, or what as an academic I might call mutual aid, helping one another, mutual aid, helping. And so we have a responsibility to cultivate and develop our gifts and to share them when and where appropriate. And the flip side, we bear responsibility to communicate when we have a need so that someone else might share their gifts with us, and we're responsible to be humble enough to accept that gift when offered. Unless we accept responsibility for ensuring that our needs are met, we won't be in a position to share our gifts, and everyone's counting on them. So we're nowhere near done the sequence I want to run us through here yet, but I just want to draw attention to the fact that already we have here the elements of Elder Bones' statement about treaty, a relationship premised on our sharing responsibilities. The question arises, how do we know what is appropriate sharing? That is, what kind of boundaries frame our sharing relationships? And the answer that I've learned from this Anishinaabe account of creation or natural law that it furnishes us with is kinship. So that's to say, when Creator brought all of the orders of creation, again, animals, plants, those physical features, hills, lakes, when he brought all of that into being and gave or imbued each of them with gifts, he also brought them into a specific relational order. And from our standpoint as Anishinaabe, we call the sun grandfather, the moon Nokomis, grandmother, the earth mother, animals our elder brothers, and so on. And the point of doing that, of noting that we do that, is that each of these kinship positions bears a specific set of responsibilities towards the others. So the sharing responsibility that brothers have for one another is different from the kind of sharing responsibilities that children have with respect to parents and parents with respect to children. And that applies throughout every imaginable kinship position. And they're highly specified, right? So in Anishinaabe MOM, the word, for instance, for aunt on one's father's side is not the same as the word for aunt on one's mother's side. Ninoshe and Nizekos, but I can never remember which is which. But the reason for that is they have different responsibilities. So the final step here is that we take that the inherent order in creation to be good. It's not, it isn't just that it is good. We see the way those animals, plants all connect with each other, and we see predation, and we see lots of complex ways in which animals and plants and the whole earth community sustain a state of wellness. It's not a romantic story. Obviously, people eat each other. There's occasionally trophic cascade, all those ecological processes. But the general idea is that even where there's competition, that's actually just one of the ways that mutual aid plays out. So a classic example, that wolves typically eat sick deer, etc. So this final step here is that since it's good, we try to build our communities to fit within it, which is to say, sharing or mutual aid and kinship serve as the foundational principles for our human communities too. Now, just before making the leap to treaty, we have to stop and say that all Indigenous peoples of Turtle Island offer some account of these dynamics. The creation stories differ a lot in their particulars, but they all disclose the same foundational set of understandings about the nature of the inherent order in creation, what it means in terms of individual responsibilities, and the desire to build our systems of law, our communities, from this foundation of kinship and mutual aid. And I'll just, maybe just in the comments, rather than share screen, I'll just post one of my, there, for anyone who wants to see for themselves. So you have in this document, when I'm talking about a vision of kinship and of mutual aid as a way of existing in relationship to one another. This comes from the Turtle Lodge many years ago. Obviously, I was not an elder participating in this. I was just a young guy hanging out, but I was around. It was very exciting for me. I was deeply moved by the process of creating this document, all those elders who were part of it. And so you see here, Anishinaabe, Nahado, Dakota, elders from different nations, all sharing. The languages change, the ceremonies change, but there are these shared understandings in terms of kinship and sharing that cut across the great diversity that characterizes our peoples. So then the last thing is, because this account of treaty, what we might call the rooted in the earth account, was shared by Indigenous peoples across their great diversity, we naturally expected the newcomers too would participate in this kind or vision or account of treaty relationship that everyone else does. And more importantly, which is the Earth's own model of community. So, just coming up to the end here, what does this really mean in its particulars? This relationship, or more specifically, kinship account of treaty? Well, it means there are no rights. There's no claiming against the other side. There's no provisions. It's not a contract. No written document that even could be litigated before a court. Just the relationship itself is the treaty. So treaty doesn't mean document. It means this kinship kind of relationship, which is inherent to Earth's own order, and which we mimic, which we recreate because we take it to be good. And we can do better or worse in this relationship premised fundamentally on sharing, in meeting our responsibilities. And insofar as determining what those responsibilities are, we have to first ask what kind of kinship relationship is the one that defines us as treaty partners. And so you see in virtually thousands of places in archival material, the invocation of kinship positions in relationship to Indigenous settler interactions, including writing the record of treaty negotiations. In the case of Manitoba, you see this right in the commissioner, Alexander Morris, right in his own records, his use of this discourse, the importance of kinship. So both French and British treaty partners. So before the fall of New France, many of the Indigenous nations beyond the Haudenosaunee were allied with the French partner, not with British. And in those documents too, and their practices, understood and used the importance of kinship and the sharing of gifts. And involve themselves right in the institutionalization of gift giving. So in my own teaching about treaty in my classes, I work very slowly through primary documents to show students where these things exist so they can see for themselves. And I prepared some of those documents for us today, but given the sort of technical difficulties, and also we're short on time, so I want to leave some space for questions. I won't share them. I'm happy to circulate though through the TRCM if folks want to see just one or two for themselves. And then just the very last thing I wanted to say is often when I present this idea to folks that we relate as kin, they, I think, naturally get worried. Some even take offense when they see in the documents that the British representative refers to us as children. And we often refer to ourselves as children. And they read that against the significance we attach to the roles of child and parent in terms of authority today in modern Canadian society. And the piece that's missing there is that for Anishinaabe then, and for many of us still today, the social dynamics of those roles and the kind of authority couldn't be more different. And that relationship between parent and child is not one of subjugation. The child is not under the parent's authority in that sense. I remember my first time in a traditional lodge made with poles and hide, and there was a 2-year-old running all around, and the parents just let it happen, and no one was even stressed about it. And at one point, that parent bumped right into the elder who was speaking in the ceremony, and he just sort of casually looked down and didn't get frustrated, didn't smile. It was like it was nothing at all. Just was like, hey, there's a child there, and then continued on. And even then, the mom didn't jump up and grab that kid. Everyone was just relaxed because we afford our children, from a Western standpoint, quite extraordinary autonomy to find their own way, to figure out for themselves what's appropriate behavior, and then to impose those boundaries on themselves. And so when we use this language of parent, child, and if we call the king or queen or whoever it was at that time our great father or a great mother, we're not acknowledging authority over us. We're acknowledging their much larger responsibility to share gifts in our treaty relationship than what we have for them. It's in the sense of distribution of gifts and needs, it is not equal in that way. And I'll read maybe just one or two documents to help show that. And so this one from now just a little more than 250 years ago, it was in 2014, the Treaty of Niagara in 1764. And just following that treaty, the highest ranking colonial official in British North America, Sir William Johnston, was writing to the Lords of Trade. And I'll just read this one paragraph from a quite lengthy letter. He says, I have just received from General Gage a copy of a treaty lately made at Detroit by Colonel Bradstreet with the Hurons and some Ottawas and Mississaugas and Anishinaabe. These people had subscribed to a treaty with me at Niagara in August last, but by the present treaty I find they make expressions of subjection, which must either have arisen from the ignorance of the interpreter or from some other mistake. For I am well convinced they never mean or intend anything like it, and that they cannot be brought under our laws for some centuries, neither have they any word which can convey the most distant idea of subjection, and should it be fully explained to them, and the nature of subordination, punishment, etc. defined, it might produce infinite harm. One document, and then I'll just read very quickly from another one. So this is Sir William Johnston, General Gage, and it was written the very next day, This is from October 31st of 1764. It's necessary to observe that no nation of Indians have any word, and so he says no nation of Indians, but they're talking about the Haudenosaunee and the Western Confederacy, which was essentially, with the single exception, all Anishinaabe nations. It's necessary to observe that no nation of Indians have any word which can express or convey the idea of subjection. They often say, "We acknowledge the great king to be our father. We hold him fast by the hand, and we shall do what he desires." Many such like words, of course, for which our people too readily adopt and insert a word very different in signification, never intended by the Indians, without explaining to them what is meant by subjection. Okay, so I'm trying to say there's a contract vision of treaty, there's a relationship, specifically kinship vision of treaty, which doesn't have provisions which can't be brought to court because it isn't settled. The whole point of an ongoing relationship is just to share with our kin. And as kin, we actually want to take care of each other. We understand that's part of our responsibility. And since there are no settled terms and it's a relationship which is organic and always changing, what would be exchanged when we met each year varied with what our needs and gifts were. And we always had to work it out in real time. And so renewal, to recreate that relationship, to feast that relationship on an annual basis, was a principle that was built right into it. And so we have kinship on the relationship account, we have kinship, mutual aid or sharing, and then finally renewal, because relationships always change. And if we want to keep it a strong one, where we're sustaining the dynamic of maybe it's parent-child, maybe it's brother-brother, which was also often the case for a more equal give and take of gifts and needs. But if we want to keep those dynamics the same, we have to get together. We got to feast and share and figure out, what are my gifts at this time? What are your needs? How can we support each other? So I think that's all I wanted to say, is to lay out the two visions. Many folks won't have heard previously of an Anishinaabe account. And so my hope is to empower folks with just some knowledge and decide for themselves to question some problematic aspects of the orthodox contract account, and then to at least begin to understand some of the basic elements of an alternative Indigenous account, which is not only open to non-Indigenous folks, but from my understanding, to which they have already been welcomed and is for everyone. That's it.